Assalamualaikum warahmatullahi wabarakatuh, and hello everybody. My name is Nur Azura binti Muhammad Yusuf with my matrix number 2023377307. Today I would like to review my case study on cybersecurity for Pushpa Rajan anak lelaki Tanjana versus Chin YE with civil case number WA-23CY-36-08/2017. First and foremost are the overview of the case study. Number one, facts of the case. Number two, issues of the case. Number three, judgment of the case. And lastly is analysis and critique. Facts of the case. The case is about Pushpa Rajan, anak lelaki R. Tanjanamurthy versus Chin Yi, revolves around a defamation claim filed by the plaintiff against the defendant, alleging that defamatory iMessage was sent to the plaintiff's wife. Now we go for issue of the case. For this trial, the court has been using Order 33A, Rule 3 of the Rules of Court 2012 and the amendment to Section 3, 15A, 16, 17, 17B, and 69 of the Courts of Judicature Act 1964 and amended through Courts of Judicature Amendment Act 2020 have been totally utilized since the witnesses was away, which means this trial has been happened online. List of the witnesses as follows: SP1, Bilashani anak perempuan Rahman; SP2, Pushparajan anak lelaki Tanjanamurthy; SP3, Marla Selvi anak perempuan Raju; and SD1 is Chin Yi. Now we go further for the first issue of the case. Issue number one is whether there was a defamatory short messaging service message made by the defendant against plaintiff. The plaintiff failed to establish that the defendant owned or used the iCloud email address michelle0x@icloud.com from which the message was sent. Issue number two, whether the defamatory short messaging service message referred to the plaintiff and had been published to third party. Section 114A of the Evidence Act 1950, the court noted that the presumption of fact regarding publication could not apply because the plaintiff did not provide sufficient evidence linking the iCloud account to the defendant. Issue number three, whether the short messaging service is defamatory. The iMessage was presented as a screenshot, not the original message, and lacked critical identifying details such as the defendant's phone number or profile picture. Now we go further for issue number four. Issue number four, whether the statement was published to the third party. The message was received only by the plaintiff's wife, SP3, who later showed it to the family members. The court deemed this as insufficient for broader publication. It is also provided under Section 122 of the Evidence Act 1950 that the communication during the marriage is considered a privilege between husband and wife. So last issue of the case is whether the plaintiff suffered any loss and damage as a result of the defamatory short messaging service message. The court highlighted minimal harm due to limited dissemination of the message, citing precedents like Doe, Jones, and Co. versus Jamil. In every trial, the most awaiting part is the result. So here we go, the judgment of the case. Number one, the plaintiff failed to prove on the balance of probabilities that the iMessage originated from the defendant. Number two, the defamation was dismissed due to lack of evidence linking the defendant to the iMessage, minimal publication impact, and insufficient evidence regarding the defamatory nature of the message. Last judgment of the case is the legal principle reference. In terms of elements of defamation, the statement must be defamatory refer to the plaintiff and be published to the third party. The last part of my case review is the analysis and critique. So first is the central issue. The primary dispute was whether the defendant sent the alleged iMessage. The court emphasized the plaintiff's burden of proving ownership of the iCloud email used to send the message, despite the plaintiff's reliance on Section 114A of the Evidence Act 1950 to create the presumption, and the argument is failed. No direct evidence linked to the iCloud email address to the defendant, and the defendant denied ownership of the email and profile were absent from the screenshot. Second analysis is the authenticity of the evidence. The court did not accept the screenshot of the iMessage as conclusive evidence, where the original iMessage was unavailable and the plaintiff claimed that it was deleted by the wife. The plaintiff's reliance on the screenshot without proper authentication weakened the claim. Third one is the publication of the defamatory message. Although the court recognized that the communication to a spouse could constitute publication, it dismissed the claim due to the limited publication to the plaintiff's wife. The reasoning followed precedents that the minimal publication may not warrant defamation claim. The screenshot of the iMessage was marked as identification document ID 13 and not formally admitted as evidence. The court stressed the importance of authentication evidence in digital defamation cases. The last analysis is the court highlighted the absence of direct Malaysian precedents regarding iMessages and referred to the international cases, the Vaughan versus Vaughan 2015, to address the potential hacking or alteration of such messages. There are some critics and areas for improvement for this case. First, the case underscores the challenges in proving digital defamation. The plaintiff's failure to involve technical experts to verify ownership. Second one, the judgment could have delved further in the plausibility of third-party impersonation or misuse of defendant's name in the possibility of hacking but did not fully explore its implication. And third one, while the court dismissed the claim against the defendant, it could have further scrutinized the defendant's denial of ownership, considering circumstantial evidence presented by the plaintiff. In conclusion, this case demonstrates the complexities of defamation in the digital age, particularly in proving the authenticity and the origin of the electronic communication. The judgment highlights the need for robust evidence and experts' involvement in similar disputes. While the court's reasoning aligns with established legal principles, it also underscores the evolving challenges of addressing defamation in a technologically advanced era. Thank you.